Hello and welcome to interest.co.nz. I'm Gareth Vaughan with another of our double shot interviews where we bring in CEOs, business leaders, people of general interest that we think you'll be interested in hearing from. Today I'm joined by Sean Hughes, who is the Chief Executive of the Financial Markets Authority. Thanks for joining us, Sean. We appreciate your time.
Thanks, Gareth.
Look, obviously you are now a year into the FMA. It's the first birthday party for this new government regulator. When the FMA was introduced, the then Commerce Minister Simon Powell made a lot of how he wanted the FMA to be the sort of key plank of trying to restore the ma and pa retail investors' confidence in the financial markets, which obviously took a hammering with the collapses of all the finance companies in the last 4 or 5 years. To what progress do you feel you've made thus far towards restoring that confidence?
Well, I think it's a really good question, Gareth, because the focus of the past government, and indeed this government, is really around restoring confidence in the market. I think we need to look at the collapse of the finance company sector, though, within the confines that it occurred. First of all, there was not a collapse across the entire New Zealand economy. Yes, there was a GFC, which impacted many of our closest trading partners as well. But the collapse in terms of investment confidence did occur in a fairly narrow sector of the market, and that was a number of those finance companies, as you say. I think one of the other concerns I'd add to that is that a number of those investors may have had repeated experiences of losses in the finance markets, maybe going back to the equities collapse in the late 80s, the dot-com collapse in the 90s, and potentially therefore suffered a third collapse. And now they're facing a very, very severe, potentially difficult retirement. So the government was clearly keen to raise the confidence levels, and that's not something that's going to happen overnight. These are incremental steps. You've got to build the foundation for that confidence to be restored. First thing that's happened is that the markets have themselves recovered. There has been a growing enthusiasm about a range of different investment vehicles, so we're seeing that confidence starting to come back. We've been established, obviously, with a mandate to police the market to make sure that investors have confidence because they believe that market participants understand their obligations and are complying with them. But these are very early days. Now, you refer to the fact that we're 1 year old tomorrow. That in of itself is really just a moment in time. I mean, I'm seeing this as really a 3-year journey to the point at which we can say, well, there are a number of things that have been achieved. A number of those things are regulatory changes that are being pushed through at the moment. But I would say you wouldn't expect to see the sort of exponential growth and confidence in the market until the end of this first initial period.
You came in for one of these interviews a year ago, just prior to the launch, and you said at that point that restoring confidence wasn't a job for one man or one organisation. Everyone needed to roll up their sleeves and help. How much support do you feel you're getting? Is the FMA getting everything it needs to try and achieve this outcome?
Well, I think I'd look at it across a number of different sectors. So firstly, that part of the market that we've begun regulating at the earliest point was the financial advisors. And after some initial cynicism and I suppose concerns about whether this was overbearing regulation or over-costly regulation, we're starting to see some encouraging signs from the advisor community about actually this is good for business. Now we understand people will say, there's a compliance cost there, but actually as investors feel confident going to their advisor and saying, actually I can see increased standards of behaviour, they're more knowledgeable, they understand my needs better, and therefore that hopefully leads to confidence. So that's on the intermediary side. In terms of market participants themselves, we've had a really good reaction to our second round of consultation in terms of effective disclosure for prospectuses and investment statements, and that's been a really interesting exercise for us in terms of how we work with the market, because it's not about setting hard and fast black letter rules, it's actually saying what works for this market at this point in time. In terms of government, we've been very well resourced by the government in terms of our funding for the next 3 years. Obviously we have to work within our means, and we're conscious that we can't do everything that we might want to do, so there's going to be some choices probably in the next year or so about what we do and what we don't do. And then in terms of retail investors themselves, I think that's probably the one area where we need to focus some more attention is in terms of investor education. That is difficult because there are a number of other players, both in the public sector and the private sector, who are involved in investor education. It's quite a crowded space. So we need to decide for ourselves, where does the FMA sit in all of that, and what can we do to be effective in raising confidence and understanding of financial risk.
You mentioned just prior to that comment the 3-year journey. What would you hope to see in 3 years' time? I mean, I assume we're 1 year into that now. I mean, where would you hope the FMA would be then, and the New Zealand financial markets at that point?
Well, speaking purely selfishly, I think it would be nice to see the FMA accepted as part of the marketplace and having a valid and respected role. And that's something that we recognise we have to earn. But if I look at our role vis-a-vis some of our peers in other countries, not just in Australia, but for instance, say, in Southeast Asia or in the UK or America, I think the role of the regulator is pretty well understood, not always agreed with, but pretty well understood and respected in each of those sophisticated markets. And I'd like to think that FMA reaches that level of maturity and understanding within that time period as well. I think as we're already seeing increasing numbers of inquiries and complaints coming to us, that would suggest to me that we've raised our visibility and that retail investors in particular see us as the go-to place where they have concerns about financial markets issues. Thirdly, and this is really encouraging, we're starting to see market participants coming to us directly and raising concerns about issues that they're seeing in the market. Now, many of those are tip-offs or concerns that they want to express to us behind closed doors. That's fine. As I think I said to you when we caught up a year ago, that sort of information is absolutely vital for us in terms of looking ahead, identifying where the risks might be in this market and targeting our resources. I suppose a longer term goal for us would be seeing active participation by investors across a range of asset classes. So obviously we have a keen interest if the mixed ownership model goes through in terms of these proposed state-owned enterprises floats. To see active retail participation in those, I think, will be an indication of a restoration of confidence.
Yeah, that was one of the things I wanted to ask you about, because you did mention last year that one of the long-term measures of success for the FMA would be to see more New Zealanders comfortable investing outside property and also outside just cash, bank deposit type area. So that SOE float program, is that a pretty important thing for NZX as an investment option?
Absolutely, and in fact, rather than just say focusing on that area, I would say that where KiwiSaver has a critical role to play is in developing and deepening New Zealanders' understanding of financial markets and the different components of the financial markets. So whether you're a director investor potentially down the track in Mighty River Power, or through your KiwiSaver fund you're an investor in those sorts of asset classes, I think that's a good thing, because what will happen is that as markets are cyclical and as they go up and down, hopefully with a spread of assets, people will be insured to some extent or won't feel the same sort of severe downturn that they might have incurred if they've just been in property or just in cash. And
also, in terms of the finance companies, obviously you inherited the investigations such as they were when the FMA came into existence. I think from my calculations you said about 16 were ongoing last September. You've made some announcements on about 3 of those, I think, so that leaves about another 13 still ongoing now.
That's right. So we've got 13 ongoing investigations. They're at different stages of maturity, as you can understand. We've got a relatively new team of investigators, some of whom we've brought in directly from the market, from law firms and from forensic accounting firms. And they are working their way through. Now, I'm not in a position today to announce which ones are most developed and which ones we're getting ready for court. But clearly we're focusing on those where we think we have the strongest case. And that is consistent with the enforcement policy you might recall we published last year. We thought it was important to put out in the market the sorts of criteria and priorities that we apply when we're looking at investigations. Now, as frustrating as it is, we know we've got to work our way through that list of cases that we were handed by the Securities Commission when we were set up a year ago. A number of those cases have had significant impact on investors, both in terms of actual loss, but also in terms of their confidence in the market. So it's in that context that I want to say that we are focusing to make sure that the lessons are learned from the past decade, that directors who failed in their duties are held to account, and importantly that we get the right sort of outcomes that either compensate investors wherever possible, but also send a strong deterrent message to the rest of the market.
And one of the key new powers that the FMA got was the so-called Section 34 power, whereby you can step into an investor's shoes and take civil action and try and recoup some money against directors, trustees, auditors, the like. Any plans to actually jump in and use that power yet? And if so, would it be in the finance company space?
I think it's more likely that you'll see it used in the finance company case to start with, and obviously what we want to do is get through these existing prosecutions that have been taking up so much of our time recently, and then look at the civil cases. Now, a number of those criminal prosecutions that were launched also had civil cases attached to them, which were stayed until the outcome of those prosecutions. And as you'd know as well, we've announced civil proceedings in relation to the Hanover directors and promoters. So we're looking at those cases at the moment as our first point of focus to say, well, which of those are appropriate for a Section 34 type action. The issue around Section 34 is it's a bit different to a normal Securities Act case. What we're doing there is we're saying, if I was an investor in the FMA's shoes, would I have a right of action against either the trustee or the auditor or potentially the directors themselves? And what sort of assets or recovery might I be able to get from them, either directly or through their insurance? Now, those cases have to be brought in the public interest, and so we've got to satisfy quite a significant public interest threshold to meet that test. So we're not rushing into it because we are obviously using taxpayer funds when we run those cases. I understand there's a lot of interest and potentially some impatience about us getting to the door of the court on those cases. And I can assure you we are looking at them, but we're not going to make a hasty decision just for the sake of saying, well, we've done our first one, and clearly we didn't try to set ourselves, one in our first 12 months.
Are there any cases you're actively considering now as potential Section 34 actions?
Well, I think we've made it clear in terms of our announcement in the Hanover proceedings that we are looking at not just the liability part of that decision, so the declaration of civil liability and the penalties, but we're also looking at a broader compensation claim. I don't want to talk too much about that matter because clearly it's now before the courts, and we've got to wait and see what defences are put in. But clearly the continuing asset preservation orders in relation to Mr Hodgson are designed to ensure that we can preserve assets for the benefit of any future investor claims, whether they be us directly or on behalf of investors. Just in terms of Section 34, Gareth, you'd also be aware that there are plaintiff lawyers that are looking at potentially bringing class actions as well. So in this litigation space, we've got to be mindful of the interests of not only ourselves, of the receivers, but also potentially those class action lawyers too.
And just in terms more broadly of the FMA, are there any more tools or laws that you are keen to see come in?
Well, at the moment, we're obviously very keen to see what progress is made in terms of the Financial Markets Conduct Bill. It's had its first reading, has now been referred to the Commerce Select Committee, and the Select Committee will be having its first public hearings very soon. We're acting as an advisor to the Ministry of Economic Development through that process, and we want to see what comes out of that. Now, we've been very pleased to see the sorts of proposals that the government is making in terms of simplified disclosure, a much broader licensing regime to include market participants such as fund managers or discretionary lenders, peer-to-peer lenders, and also the new tiered liability regime for directors. So those are really important things to get through. Now, let's see what happens in terms of negotiations through the course of that bill through Parliament. If things are taken out of that we think are critical, that's something we'll be going back to government on. At the moment, I have to say, we're pretty comfortable with the range of powers that we've got. We're comfortable with the range of our financial markets oversight, and we've got a big job to do over the next couple of years. If at some point in time somebody says, well, there's more responsibility we want to send the way of the FMA, we'd have to have a discussion about, do we have the resources to do it? For the moment, I'm comfortable with what we've got.
So one more question on finance companies. Obviously, if you go back 5 or 6 years, there were a lot more of them around. In terms of the ones who had prospectuses open seeking retail debenture money, there were, I think, 60 plus now. By our calculations, there's around a dozen. Do you think this retail debenture funded finance company model has a future in New Zealand?
I would hope that it has a future in New Zealand, because I'm very keen for us to have a whole range and diversification of products that are suitable for different types of investors. So I'd hate to see, as a result of the finance company collapse in that sector, a whittling down of opportunities for New Zealanders to have choice. But at the end of the day, regulation and regulators are only there really to ensure that the participants understand the rules that are written by Parliament. It's going to be market forces that really determine whether a particular asset class or product stays in existence or not.
And in terms of the financial advisor regulation, are you confident that that's going to protect investors?
I think it's done a significant job in terms of lifting the standards. If you remember, Gareth, in July last year, or up until July last year, you or I could have called ourselves financial advisors, and we could have got away with it. Now we've got a regime in place that does put some rigour around that title. I think it should be seen as what it is. It's a profession. Financial advisors who've gone through the trouble of becoming authorised, taking on additional qualifications and assessment, and who are really doing the right thing by their customers and their clients should be applauded for that. The MED and the government are going to be reviewing the whole regime, I think, within the course of the first 5 years, and obviously they're going to be looking at a range of things at that point in time. I can imagine there'll be a consideration of the whole classification regime between AFAs, RFAs and QFE advisors, and I think that's really important they do that. And undoubtedly things such as the remuneration model, the fees versus commission debate that we've had in Australia will also come up as well. But for me, the big issue for advisors at this point in time is how do you get the right quality of advice tailored to the needs of individual investors, and that is an ongoing issue. Our monitoring visits to date have indicated in the 4 regions that we've been so far that advisors are taking their job seriously and they understand that the bar has been raised. We are going to have to move though at some point in time soon where we move from a sort of an educative role to a more pointy-edged sort of enforcement role, and that's appropriate given that advisors will have had a year to get used to the new regime.
And if finance companies were to some extent the past, do you think that in the future the FMA is going to be looking more closely at the KiwiSaver sector? I mean, that's obviously a huge area of growth in the New Zealand financial markets.
Absolutely, and I see KiwiSaver as not just a great opportunity for investors in terms of their retirement future, but also a regulatory risk for us to focus on. It is a little unusual compared to Australia in that there isn't the same regulatory regime for retirement savings as there is in Australia, where you've got a very significant prudential regulator and APRA, and then you've got ASIC, the conduct and disclosure regulator. Here we have a slightly different regime in that you've got the IRD doing the sort of the administrative regulatory piece, you've got FMA doing the disclosure and conduct piece, and also we've got a role in terms of licensing and oversight of the trustees. But that prudential piece is the bit that's missing. And I think that KiwiSaver and the risk around KiwiSaver is something that I think not only government but we as regulators have got a paramount duty to ensure that it's working well for members.
And one area we've been writing about quite a bit at interest.co.nz recently is companies that register in New Zealand through the company's office and then offer financial services overseas. They're largely unregulated, not entirely, but largely unregulated. How big of a concern is this area to the FMA? I mean, I know I've been talking to some of your staff recently about one of the companies we wrote about, City Savings, which was calling itself a bank for a while. We've also written about New Zealand registered building societies, one of which claims to have about $5.5 billion US worth of mining assets under management, which seems an unusual scenario for a building society. So how big of a concern is this area, and how much time do you spend focusing on these companies, because there seems to be a never-ending stream of them?
Well, it's today's version of the Nigerian letter scam, really, isn't it? I mean, I see these things as never going away, and as fast as we shut one door, another one will open up somewhere else. And that just means that we've got to be very vigilant. We do rely to a large extent on information that's brought to us by complainants, by others such as yourself, Gareth, and by other informants in the market that are letting us know about these things so we can take action. And as you rightly said, in the City case, we did take action. They've corrected all of the inappropriate or misleading disclosure that was complained about. But we've just got to stay on the case. That's why we set up the strategic intelligence function when FMA was established a year ago, and that function is now operating. It is out there looking in the market to see where the risks are. But this sort of question of New Zealand being seen as an easy place to set up and then market your financial services offshore is going to be an issue that we face under the regime we have. Now, we've talked to government about it. They understand our concerns. There are issues coming back the other way as well, as you would know, in terms of people overseas with criminal convictions being able to set up in this country because their criminal convictions aren't taken into consideration on registration. These are all things that ultimately go to undermine confidence in New Zealand's financial markets, whether they be from domestic investors or from foreign investors, and therefore it is something that we need to stay on top of. Now, I understand the government has priorities. It's not always going to see these things as top of the queue in terms of legislative reform, in which case we've just got to be more skillful at heading them off at the pass and taking the sort of action that we did take on Citi, or in terms of Mako Securities was another example where we leapt in there and tried to stop them doing what they're doing.
Do you think that that the government needs to make it harder to register as a company in New Zealand, or any particular thing they could do to perhaps slow down this wave of offshore finance companies?
Well, I think the government, and rightly so, takes pride in the fact that New Zealand continues to be seen as a very good place, an easy place to do business. And New Zealand is seen as a developed market, as an advanced economy in the world, and so therefore the New Zealand brand for a foreign company setting up business here is a huge advantage. We don't want to clamp down on that New Zealand easy to do business philosophy, but at the same time there do need to be some protections so that New Zealand's reputation is not tarnished. So as I say, happy to talk to government about it, but at the same time we've got some tools. We're using those tools wherever we can.
Well, thanks for that, Sean. That's Sean Hughes, who's the Chief Executive of the Financial Markets Authority, and I'm Gareth Vaughan at interest.co.nz with another Double Shot interview.